Okay. Hi, this is Brad Aldrich from Aldrich Legal Services. Today I'm going to be talking about search and seizure of a home. So at the core of the Fourth Amendment is an individual's right to be free from governmental intrusion into their home. This is often known as a search and seizure. So any type of analysis from a legal perspective starts with the concept, for search and seizure, starts with the concept of, was this with a warrant or without a warrant? Now if it's with a warrant, that means that a police officer went to a judge and was able to prove that there's enough evidence for that judge to issue a warrant. That's a completely different scenario and is much harder to attack from a legal defense standpoint. So today I'm discussing what if there's a warrantless search. So when there's a warrantless search, the law presumes that it is wrong per se, but then there are a number of exceptions. So you would have something like hot pursuit, where a police officer is actually in hot pursuit of a criminal and then discovers something. If it's in plain view, if they get consent from an individual, sometimes called a knock and talk, whereas a police officer knocks in somebody's home, talks to that individual, discovers evidence that allows them to then conduct a search and seizure. Well, there's a case on point that I wanted to discuss that kind of sets out this concept pretty easily, which is that a police officer was investigating the stolen motorcycle and discovered on Facebook that somebody had posted a picture of the motorcycle for sale. So they went to this individual's home, saw what appeared to be a motorcycle under a tarp in the driveway. Without a warrant, the police officer went, looked under the tarp, saw it was the stolen motorcycle, and arrested the defendant. The Court of Appeals overturned the conviction, claiming that the police officer had no excuse for the warrantless search and seizure, meaning it wasn't in hot pursuit, it wasn't in plain view, and that police officer actually went onto the curtilage of the person's home. Curtilage is defined as the area sort of surrounding the actual structure of the house. And without any type of special circumstances, an exception to the warrantless search and seizure rule, the evidence that was discovered by that officer was not admissible, so the case had to be dismissed. So if any of you are charged with any type of criminal matter, the lawyers at Aldrich Legal Services can certainly help.